This Honorable Court of Tennessee is now in session.
Good afternoon. This is the May session for the Court of Criminal Appeals in Nashville. The panel today is Judge Robert Montgomery, Judge Tim Easter, and I am Norma McGee Ogle. I understand that, Ms. Coleman, you would like 5 minutes in rebuttal. For rebuttal, is that correct?
Yes, Your Honor.
Okay. We're ready to have the case called.
State of Tennessee versus Noreeldeen, Abdulkarim.
Thank you. You may begin.
Thank you, Your Honor. My name is Erin Coleman, and I'm representing Noreeldeen Abdulkarim today on his motion or his appeal of a of his case on his motion to withdraw his plea, which was denied in trial court. We have really two areas in which we believe that this case or this plea should be overturned. The first and the most important is that the trial court erred in stating that the defendant knowingly, voluntarily, and intelligently pled and understood the full extent of his plea. Under Blankenship, versus state, it is determined to we must use Blankenship versus state to determine whether or not he knowingly, voluntarily, and understandingly entered his plea. And in those, we look at the intelligence of the defendant, the understanding of the criminal process, the representation by competent counsel, whether he conferred with counsel, the extent of the advice by counsel and the court on the charges against him, and his reason for guilty plea. All of these must be accommodated in order for a plea to be knowingly, voluntarily, and understandingly taken. In this particular case, we would argue that my client, Mr. Abdulkarim, did not understand, and he was not given complete advice by counsel or the court on the extent of the charges and the plea and its implications on his life. We state that because he denies being told that he was going to be on lifetime supervision, lifetime community supervision, which was a requirement of the plea. When we were in taking the plea in the plea colloquy, there was no mention on either the plea paperwork or in the plea colloquy of the requirement for lifetime community supervision or being on the sex offender registry for 10 years. That being said, obviously with the court not stating that or it being on the plea petition, the court in no way gave advice to my client on the extent that these two very, very extensive requirements would have on his life. And they did not in any way ensure that he understood the extent that these requirements would these requirements would have an impact on his life, or that he understood the requirements of him once being released from prison. Additionally, in Calvert versus State, we find that the trial court failed to tell a defendant about the lifetime community supervision requirement. That is exactly what happened here. In that case, the appellate court did overturn and allow the defendant to withdraw its plea due to that lack of information on the lifetime community supervision requirement. And we find exact duplication between the Calvert case and this case. And so we would ask your honors to abide by the precedent set in Calvert and allow my client to withdraw his plea at this time. Here, as in Calvert, not only was the lifetime community supervision negated from the plea colloquy, but additionally, his sex offender registry obligations were also not stated in the plea colloquy. So even more so than Calvert, my client was not given any advice or was not in. And the trial court did not ensure that my client completely understood the extent and obligations of his plea. The state in no way it is on the state to prove beyond a reasonable doubt that the defendant already knew the obligations of the sex offender registry and supervision for life requirement, and the state in no way can prove that beyond a reasonable doubt. We do understand and agree that his trial counsel, during the motion to withdraw a plea, stated that she had an extensive conversation with him specifically about the implications of the sex offender registry, and that he was very adverse to the sex offender registry, and that she had to have conversations with him about what those requirements would be. But as you would see in the transcript from that motion to withdraw a plea, you will not see her stating specifically that she had extensive conversations with him about the lifetime community supervision requirement, which is very, very important, obviously, because it takes on a requirement for the rest of your life. So although, and additionally, that conversation is one between an attorney and a client. We don't know exactly and can never know exactly what was said. My client states that he did not know the requirement of the sex offender registry, and we ask that your honors take that at the same level and balance his testimony of not understanding and knowing about the sex offender registry requirement in line with the trial attorney's statement that she did speak with him about that. Because those were conversations behind doors, and because the requirement of the sex offender registry and the lifetime community supervision were not on the plea petition at any point in time either, in addition to being negated from the plea colloquy, we believe that the state in no way can prove beyond a reasonable doubt that those conversations actually occurred beyond the trial counsel's testimony, and I respect the trial counsel. She is a good friend of mine. I just want to put that on the record, and I think she's a wonderful attorney. So probably not appropriate for me to say, but I do want that to be said.
Let me ask you this.
Yes.
And I only have what's in the briefs to go by today,
Yes,
but it appears is there anything in the record where she clearly distinguishes that she's clear on the sex offender registry and the lifetime supervision? Because what's in the record, it looks like she's almost talking about them as one.
Yes, and I would agree with you. And obviously, they are very, very different requirements, and she does not differentiate in her testimony between the two. What she does really specifically talk about in her testimony during the motion to withdraw the plea was specifically her extensive conversation with him about the sex offender registry. She never once states how extensive her conversation with him was on the lifetime community supervision requirement. And obviously we know that those are two very different requirements. And so it's our argument that that requirement wasn't properly explained to him by her. There's no testimony stating that she specifically explained that to him. And on top of that, the court never once explained the requirements to him during the plea colloquy. And because of that, really, this plea should be allowed to be withdrawn at that point in time.
So I don't find any fault, Ms. Coleman, in your being complimentary of trial counsel. I think you're still representing your client zealously.
Thank you.
I find that refreshing that you would even say that. But anyway, in the Calvert case that you cite, was there a harmless error analysis done on that? Do you recall?
I don't recall. I don't recall, and I don't want to assume on the record, but I would.
Well, I mean, it seems clear from the record or the briefs here that I reviewed, the state's not arguing that the trial judge failed to advise your client of these requirements. I don't think there's any dispute. The trial judge did not do that.
Yes, Your Honor.
I think where the dispute seems to be is then you come behind that and have the plea hearing or motion to withdraw plea hearing. And we hear from trial counsel who said, according to the brief anyway, when asked if she advised the defendant he would be subject to lifetime community supervision, at least the transcript that I see says, did you discuss the implication it would have about sex offender registry and community corrections for life? Yes, we did. And Judge Dozier at this hearing accredited that testimony, which I believe, and you mentioned a couple of times that the state has to prove this beyond a reasonable doubt.
Yes, Your Honor. And being a trial counsel myself, mostly, I would argue that a jury in this situation, with two competing testimonies and with the addition of the judge failing to put this in the plea colloquy and trial counsel failing to put this on the plea sheet. I'm sure you're familiar with Davidson County plea sheets, and everything, all requirements are supposed to be on the written plea sheet that the defense counsel writes themselves, and they and the district attorney and the defendant all sign this plea sheet, and that is part of the record, and it placed in the file. And the requirement of the sex offender registry and of the lifetime community supervision requirement is not on the plea sheet. Often in Judge Dozier's court, he and other criminal court judges in Davidson County will read directly from the plea sheet as they're giving, as they're making sure that the plea is understood. And so it is even more obvious through the absence of the lifetime supervision requirement and the sex offender registry, through the absence of those speaking points during the plea colloquy, that it was even more so obvious that it was not on the plea sheet. So I think my opinion, my humble opinion, is that a jury, if this were to go to a jury, which obviously would, I'm not sure that it would, but that there is no way to, beyond a reasonable doubt, show that the trial attorney did actually speak to him, because there's no actual evidence. There's just circumstantial and somewhat hearsay evidence of that there was a slight conversation on the lifetime requirement. I think that in a case of this magnitude, where a person is going to be placed on lifetime supervision forever and on a 10-year sex offender registry, it is imperative that we ensure that they are aware of all the requirements. And we just cannot be sure of that today, because it is nowhere on the plea sheet and nowhere in the plea colloquy. I appreciate that trial counsel believes that she took the time to do this. But additionally, just to kind of note, the time between the plea and the and the motion to withdraw was about a year. So I think taking that into account as well, which a jury would obviously take into account, there is obviously a loss of remembering exactly what was stated. So even more so,
it's just a matter of days that your client though filed the motion to withdraw. When they're like 3 days later.
Yes, he filed the motion to withdraw within 3 days, Your Honor, within that 7-day period before the plea went into effect. But we did not have the motion to withdraw the plea until February of 2020. So it was April of 19 is when he took the plea, and the end of February 2020 is when we actually ended up having the motion and having her testify in court about what the conversation entailed. And just to kind of note, I do think that it's a really important distinction that she spoke in that motion to, in her testimony on the motion to withdraw the plea, she spoke very strongly about the conversations they had about the sex offender registry, but she never once spoke strongly about the conversations and detailed conversations she had with him about the community corrections for life. And those are two entirely different obligations that my client would have to adhere to. And I think that there is just no way for the state to prove beyond a reasonable doubt that that she actually gave the proper the proper guidance on what those requirements were before the plea was given. And I think I might be out of time, but I'm happy to answer any questions before.
You have about 1 minute before you get into your rebuttal.
Okay. So we would just argue also that there was ineffective assistance of counsel because he did not understand, as we've been saying, the collateral and direct consequences of the plea. And we believe that Strickland would really abide by deficiency in performance and prejudice, and that prejudice would allow him for a new trial or to withdraw his plea at this point in time. And that we also would argue that the appellate did not knowingly and voluntarily enter his plea. On an attempted aggravated rape, he testified very emphatically that he thought he was entering a plea to something completely different, to an attempted rape versus an aggravated rape, and that was really one of the main reasons that he wanted to withdraw his plea. He in the haste of a criminal court plea, and in the haste of what goes on in criminal court every day, he did not fully understand the exact charge that he was being pleading to, and that also obviously extensively prejudices him. And so we would ask that you allow him to withdraw his plea and to move forward in this case.
Thank you.
Thank you.
General, you are recognized.
Thank you, Your Honor. Good afternoon. Austin Nichols on behalf of the state of Tennessee. From the defendant's brief, they presented 3 issues to Your Honors for your consideration. I'll address their first and third issues at the same time because the outcome of those issues is reliant in this case on the trial court's credibility determinations. And after I go through that, I'll address their second claim of ineffective assistance of counsel. So just jumping right into the first and third issue, we know in this case the trial court did not advise during the plea colloquy about the lifetime community supervision requirement. And pursuant to State v. Nagel, we then move into the harmless error analysis and a fact-intensive inquiry into what trial counsel told the defendant prior to the plea. And the courts have held that if that advice was adequate, then the trial court's omission is therefore harmless. So looking into trial counsel's testimony, she did testify at length about this issue and from the hearing back in February 2020. And she actually used the word confident. She said she was confident that the defendant understood the lifetime community supervision requirement. And Your Honors asked some questions about the ambiguity in the language used and whether or not it was clear that she understood the difference between the two. And of course, I wish that they had gone into it a little bit further back at that hearing, but I think the proof is there, and that she testified she had been a criminal defense attorney for 10 years and handled numerous cases, and I think she used the number 50 when it came to cases involving this type of charge. She went on to testify that she explained the difference between the registry and the lifetime supervision requirement, and that the charges in this case were the lifetime supervision requirement type. I understand the language is a little confusing, but it's the state's position that it's simply shorthanded, that this is how she described the difference to her clients. There's the 10-year kind, and then there's the lifetime kind, but this is the lifetime kind. And she actually did use the word confident when asked whether or not she was sure. She said she was confident that he understood the existence of that requirement. The trial court accredited her testimony fully, and he issued a lengthy order describing all of the reasons why he fully accredited her testimony. And he specifically cited some discrepancies or inconsistencies in the defendant's testimony at that hearing from February 2020. He noted that there were, at one point during the defendant's testimony, he stated he had never seen trial counsel prior to entering the plea. And then later on, he testified, I'd seen her many times, and he actually referenced conversations that they had about this case. Another inconsistency that he referenced was the fact that at one point during the testimony, the defendant said, I didn't know what I was doing. I wasn't in my right mind. But later on, he said, no, I knew exactly what I was doing. I was just being coerced. And the trial court relied on those inconsistencies when making its credibility determination. And the trial court's credibility determination is supported throughout the record of that hearing. I'd love to draw your attention to a specific point in the defendant's testimony where he was asked and where he begins during the hearing to reference a conversation that happened, that took place between himself and trial counsel. And then later on, when the prosecutor confronted him, he denied that he had said that. He said, I deny that. I didn't testify to that. And I think that that's critical, and it was critical for the trial court when making its credibility determination. I definitely want to point out to your honors that the claim that opposing counsel has referenced about the failure to advise on the community supervision for life requirement, that was a claim that was never addressed in the motion to withdraw. It was not addressed in the amended motion to withdraw, and it only became an issue after, or it became an issue for the defendant during this hearing. And in fact, he was never asked, specifically, he was never asked, did the omission of the community supervision for life requirement affect your decision to plea? As you know, the standard in this case is an abuse of discretion, and whether or not the trial court abused its discretion when fully accrediting trial counsel's testimony. And it's our position, and of course backed up by case law in State v. Crow, that a change in heart is not a manifest injustice. And unless there's any questions on this issue, I'll move on to the second claim.
Should the trial court not have addressed it then?
During the hearing, Your Honor?
Yes.
I certainly wish it had been addressed more fully during the hearing. And it's my belief that because it had never been addressed, it wasn't a claim that was raised prior to that. It was actually the prosecutor that really got into the issue, and it wasn't until redirect that opposing counsel delved into it a little bit more. And I certainly wish they had gone into it more, but the trial court found, when weighing trial counsel's testimony against the defendants, he fully accredited the trial counsel's testimony.
Thank you.
And we can move on to the ineffective assistance of counsel claim. As you know, it's the defense's burden to show that the defendant received, or that there was deficient performance, and that the defendant was prejudiced by that deficient performance. And I just mentioned this, but it's really critical in this case. Not only was the defendant not asked the specific question, did the omission of discussing the community lifetime supervision requirement, did that affect your decision to plead? He didn't testify to that, and he was not even asked that specific question. What he did talk about during the hearing was the fact that the victim hadn't shown up at court dates, and that he was frustrated and mad about the charge. And he even went so far as to say that he thought trial counsel may have hidden the charge from him by folding the piece of paper. And when opposing counsel delved into this issue during the hearing, she actually specifically asked him, so it's not the sentence you're mad about, it's the charge. And his answer was yes. And I think that's really important in this case because it seems that this issue that we're bringing before Your Honor was not an issue in the beginning. And what certainly wasn't an issue when the defendant filed his first motion to withdraw. And there actually weren't any complaints about his trial counsel until another attorney was appointed and then filed an amended motion to withdraw. In fact, I think it's noteworthy to point out that the record and the transcript from the hearing actually show that the defendant requested trial counsel. Another attorney had been removed from the case, and he actually asked for her due to a previous relationship where she had represented him before. And I think that's really important in this case. There was some talk, or there was a reference to the fact that the lifetime supervision requirement was not on the plea petition. It was on the judgment sheet, but it was not on the plea petition. And it's our position that the reason we have a harmless error analysis is to determine whether or not things that happened during the plea, for example, the plea paperwork and the colloquy, if there was an error then, is there a way that, or any proof to show that that error was harmless? And in this case, we have trial counsel's testimony about her advice to the defendant prior to his entering the plea. And we all know that the trial court fully accredited her testimony. In this case, it's for the appellate court to determine whether there was an abuse of discretion, not whether or not to reassess the credibility findings from the trial court unless the record preponderates it, and it just doesn't in this case. And for those reasons, I would ask that you affirm the trial courts.
Do you agree with Ms. Coleman's assessment that it's your burden, the state's burden, to prove beyond a reasonable doubt that this defendant was advised of these items, the supervision for life and sex offender registry? Do you agree that it's with her statement that that's on the state to prove beyond a reasonable doubt that that advice was given?
I do not. I believe the defense has raised the claim, and it is their burden to show that the defendant has received ineffective assistance of counsel.
But this is not a post-conviction, correct? This is here on a motion to withdraw, a guilty.
Correct. Right.
Okay.
If there are no more questions, I just like to reiterate that because the trial court fully accredited trial counsel's testimony and the record does not preponderate a reassessment of those credibility determinations, we'd ask you to affirm the trial court's ruling in this case.
Did the defendant ever say at the hearing that had he known about the community supervision for life, that he would not have agreed to the plea?
No, Your Honor, he did not say that. There was mention of the community supervision for life requirement, but he never testified that but for counsel's alleged failure to advise him of that, he wouldn't have entered a plea and he would have insisted on going to trial. And I think it's also telling that he was not even asked that question. He was not asked, by opposing counsel, whether or not that affected his decision to enter the plea.
Thank you.
You're welcome.
Ms. Coleman, you have your 5 minutes.
Thank you, Your Honor. Just as a rebuttal, a few points, about three. First, I think that it is notable that General Nichols, General Nichols, I hope I'm getting that right. Okay, good. I like to address people correctly. That General Nichols herself, during her argument, stated that there was some confusion and misunderstanding between, and it was obvious at the hearing that there was confusion and misunderstanding in between the sex offender registry obligations and the lifetime community corrections obligations. And those, as we've stated before, are very different obligations, and they are themselves two separate obligations that my client will have to adhere to if this plea is not able to be withdrawn. And Ms. Nichols or General Nichols had stated that it was obvious from the hearing, from the motion to withdraw hearing, that trial counsel understood what the implications of these two requirements are. But that's not the case in point. That's not the issue here. The issue is not whether trial counsel understands. It is whether my client, Mr. Abdulkarim, understands. It is imperative that he understands. He's the one who's going to have to have these burdens on his life for the rest of his life due to the plea. And so there in no way has been shown beyond a reasonable doubt that he knew of the implications of the sex offender registry and the lifetime community corrections obligations. And I think it's imperative that we really look at whether or not he truly understood the obligations of the lifetime community corrections obligations. So I think even through their arguments, the state has not shown that my client knew beyond a reasonable doubt the implications of his plea. Secondly, in the ineffective assistance of counsel argument, he was not asked. I don't think that it is for this honorable court to decide whether or not he would have entered the plea if he had understood otherwise. It is just imperative to ask whether or not his counsel beyond a reasonable doubt told him of the implications of his requirements. And I don't believe that she did, and therefore his constitutional rights to effective assistance of counsel were violated because it cannot be shown that she actually completed her obligations of telling him and advising him of all the implications of a lifetime community corrections plea. And finally, the state stated that even though it was not on the plea petition, the lifetime community corrections obligations and the sex offender registry obligations were on the judgment sheets. I think that it's very important to understand that a defendant, before giving a plea in a criminal court, trial court setting, never sees the judgment sheet. They don't, especially in Judge Dozier's court, of which I am there on a daily basis. They do not sign judgment sheets. They do not see judgment sheets. The only thing that a defendant looks at and reviews with their attorney is the plea petition. So although it is wonderful that the district attorney put on their judgment sheet that there was a lifetime supervision requirement and a sex offender registry requirement, that in no way negates the obligation of the trial counsel and the judge to ensure that my client knew of those obligations. And again, because they're not on the plea petition and because the Judge Dozier never put it into his plea colloquy, we have no way beyond a reasonable doubt of knowing whether or not my client fully understood the implications of these two incredibly harsh obligations upon taking his plea. So we would ask you to allow him to withdraw his plea and to continue the case further.
Thank you. That concludes the arguments in this case, and we are ready for court to be recessed.
This Honorable Court of Tennessee is now in recess.
Thank you.
Thank you.
I guess I'll just stay on, right, Ms. Kraft?